Can a transfer on death, TOD, deed be used for co-owned property? Have you ever wondered how a transfer on death deed works when it comes to co-owned property? This topic is essential for anyone involved in estate planning or elder law. Let's break it down. A transfer on death deed allows a property owner to name a beneficiary who will inherit the property after the owner's death, avoiding the lengthy probate process. This deed is revocable, meaning the owner can change the beneficiary while they are still alive. When it comes to co-owned property, the type of ownership matters. For example, if the property is held in joint tenancy with right of survivorship, when one owner passes away, their share automatically goes to the surviving owner. If all joint tenants create transfer on death deeds naming the same beneficiary, the property will transfer to that beneficiary after the last surviving tenant's death. However, if only some of the joint tenants have a transfer on death deed, only their portion will go to the named beneficiary. The remaining tenant will keep their share, which will then follow their own estate plan. Now, let's talk about tenants in common. In this arrangement, each owner holds a distinct share of the property. Each tenant in common can use a transfer on death deed to pass their share to a beneficiary. When one owner dies, their beneficiary becomes a co-owner with the remaining tenants in common. This means the property ownership is divided based on the original owner's shares and their beneficiaries. In states that recognize community property, the rules can be different. Typically, the surviving spouse automatically inherits the deceased spouse's interest, which can affect how a transfer on death deed operates. From an elder law and estate planning viewpoint, transfer on death deeds can be a smart way to avoid probate. This is especially beneficial for older clients who want to preserve their assets and simplify the transfer of their estate. It is essential for co-owners to communicate about their estate plans. This coordination helps ensure that everyone's intentions align, particularly in joint tenancy situations. One important point to remember is that a beneficiary named in a transfer on death deed does not have any rights to the property while the owner is still alive. This protects the property from any potential claims by the beneficiary's creditors until the transfer occurs after death. If a co-owner does not execute a transfer on death deed, their share will pass according to the default rules of ownership or their estate plan. This could lead to unexpected outcomes for the remaining owners. Additionally, it is important to note that transfer on death deeds transfer property subject to any existing liens, mortgages, or encumbrances. In summary, a transfer on death deed can indeed be used for co-owned property, but its effectiveness depends on the type of ownership and whether all co-owners participate. This tool allows individual owners to control how their interest in the property is handled after they pass away, making it a practical option in estate planning and elder law for preserving assets and ensuring a smooth transfer of real estate.